Claire Tollefson. I'm a Senior Associate in the Modern Families team here at Birketts. Surrogacy is where a woman becomes pregnant with a child who she may or may not be genetically related to, carries that child and then gives birth to that child for a family, so that in order that they can grow their family, and they would be the intended parents. Now, surrogacy is very much on the rise in this country. The number of cases has quadrupled in the last 10 years. However, the law relating to surrogacy dates from around 40 years ago, so it's just not fit for purpose in the modern world. In 2023, the Law Commission published a series of recommendations on how the law relating to surrogacy should be modernised, and one of their recommendations was that a surrogacy register should be set up, so that when a child is either 16 or 18, they can access information about their origin and better understand where they came from. Now, the surrogacy register would contain details on the surrogate and whether they were a genetic link, whether they were a genetic parent of the child, the intended parents and whether they are genetic parents to the child. If any egg or sperm donors were used, it would have their details on it too. It would also have the details of the fertility clinic where the arrangements were made, and also any other relevant information such as ethnic background and things like that. Now, it's widely recognised that a child has a right to understand where they came from, but it's really important to balance alongside that the rights of the surrogate and the intended parents and the impact of this kind of register on them. So it's widely understood that children should understand where they came from, and that they have a legal right to know. The United Nations Convention on the Rights of the Child, Articles 7 and 8, state that a child has a right to know who their parents are, and that includes both a surrogate parent and their genetic parents, and the parents who are raising them. But also a right to preserve their identity, and having the information about their birth is a really important part of their identity. Now, balanced alongside that is any concerns that a surrogate or intended parents might have about their right to privacy and their right to a family life. A surrogacy register is going to contain a huge amount of data, and it's really important that it's all kept confidential and only accessed by people who are supposed to access it. So that would be the child when they are 16 or 18. There's going to be risks of data breaches and potential GDPR issues that will all need to be managed very carefully. An important issue is where there's potentially a stigma or discrimination issue where the surrogacy is in a culture where it's not widely accepted or widely understood. So if it came to light that either the surrogate had taken part in the process or the intended parents had built their family using a surrogate, there could be discrimination and stigma attached to the family, which would impact their family life. Other issues are the impact of having that information on the child and on the wider family. The child may think at 16 or 18 that actually, yes, they do want to access all that information, but then once they've got it, not know what to do with that, and it could really disrupt the family that's so carefully been built. And there's also the child's right to privacy that needs to be considered as well, because all their details will be on this register as well, and they may not feel comfortable with having all of that information out there. It's really important, therefore, that you get some legal advice at the outset of your surrogacy journey, so that you can consider all of these important issues and make sure that you understand what information is going to be held, what information your child would be able to access, and what surrogacy route is going to be the best option for you, and make an informed decision on that basis. Do get in touch if we can help.